My name is Nomfundo Chile from the Law Society of South Africa. I'm joined by Colin Geoffreys, who sits in the Law Society's Family Law Committee, and we'll be discussing the recognition of Customary Law Marriages Act 120 of 1998. This discussion is in view of the Divorce Backlog Project. The purpose of the project is to fast-track unopposed and settled divorces to get finalized and to fast-track opposed divorces through the possibility of mediation. In this video, we'll focus on the requirements for proving a valid customary marriage under the Recognition of Customary Law Marriages Act. Hello, Colin, and welcome.
Thank you for inviting me.
Okay, firstly, Colin, can you just explain what the key requirements are for customary marriage to be recognized under law?
The Recognition of Customary Marriage Act 120 of 1998 has a section which stipulates requirements for validity of customary law. And that is fleshed out in section 3, and in particular, we look at subsection 1, where the requirements are stipulated. There are basically 3 requirements in terms of the Act. The first requirement that both parties must be above the age of 18 years old. I reiterate this here, it says above the age of 18. The second requirement is that both parties must consent to be married to each other under customary law. And the third requirement, the marriage must be negotiated and entered into or celebrated in accordance with customary law. So those are the requirements, basically there's 3 that we have in terms of section 3.1 of the Recognition of Customary Marriages Act.
And secondly, Colin, what is meant by customary law, and how can someone show that the marriage was celebrated in accordance with customary law?
The Act also, in its definition clause, it defines customary law as customs and usages traditionally observed amongst indigenous African peoples of South Africa, and which form part of the cultures of those peoples. Also, it goes on to say, a customary marriage is defined as a marriage concluded in accordance with customary law. Understandably, given the diverse number of different ethnic groups in South Africa, the Act does not define celebration in accordance with customary law. Remember, we said this was one of the 3 requirements in terms of section 3.1. The diversity of culture was highlighted in the case of Bear versus the magistrate Khayelitsha, 2005, 1 SA 580 CC. The court has commented that it is also accepted that African law and custom are not static but dynamic. They develop and change along with the society in which they are practiced or exercised. The first 2 requirements are fairly clear in terms of the Act. However, there has been some issues regarding the second one with regards to both parties giving their consent to be married in terms of the customary law. There was a recent case as well in the SCA where the issue came about with regards to consent. The SCA considered in Morapane versus Southhorn 2014, JOL 32177 SCA, The SCA found that the handing over of a makoti, the bride, to her in-laws is the most crucial part of a customary marriage. That's at paragraph 40. However, during this case also highlighted the fact that the handing over process was part of the consent where lobola was paid. But however, there were other court judgments as well that disagreed with this interpretation. So there's also some dispute, or I say disagreement or opinions between various courts with regard to what would consider to be consent given by both parties. So this is in development stage, and as we go along with case law, we will soon find out what would be the certainty that will be given to all with regards to the second one. But the third one presents more of a challenge where that is concerned. The third requirement has been considered as being fairly open, vague, because it does not qualify with any certainty the actual requirements of a customary marriage. This means that a factual inquiry has to be made to determine whether the requirements have in fact been complied with. So we will be guided by case law where that is concerned. And the Constitutional Court has had opportunity to address these issues. The courts have seemingly accepted the following three ways identified in the dissenting judgment of Nkobo J in the Constitutional Court in the matter of Bay versus Magistrate Kailicha. I did give the citation prior, it was 2005 for SA 580 CC. Firstly, the court said that taking judicial notice where it can be readily ascertained with sufficient certainty. Where it cannot be readily ascertained, expert evidence may be adduced to establish it. And having recourse to textbooks and case law, keep in mind that customary law evolves and the courts have cautioned against sole use of textbooks. The Constitutional Court in the matter of Mayalane versus Ingwenyama and another CCT 57/12 2013 ZACC 14 held that the courts must apply living customary law. And I quote, importantly, however, the Recognition Act does not purport to be and should not be seen as directly dealing with all necessary aspects of customary marriage. The Recognition Act expressly left certain rules and requirements to be determined by customary law, such as the validity requirements referred to in section 3(1)(b). This ensures that customary law will be able to retain its living nature and that communities will be able to develop their rules and norms in the light of changing circumstances and the overarching values of the Constitution. This issue was also brought up in another matter in the Constitutional Court and addressed in Shulabane and others versus Inwamitwa, CCT 03/07, 2008, ZACC 9. The court said, to sum up, where there is a dispute over the legal position under customary law, a court must consider both the traditions and the present practice of the community. If development happens within the community, the court must strive to recognize and give effect to that development to the extent consistent with adequately upholding the protection of rights. This was reiterated in the Supreme Court of Appeal in the case of Mbugela versus Mkabi. This is what the court said. The Constitutional Court has cautioned courts to be cognizant of the fact that customary law regulates the lives of people, and that the need for flexibility and the imperative to facilitate its development must therefore be balanced against the value of legal certainty, respect for vested rights, and the protection of constitutional rights. The court must strive to recognize and give effect to the principle of living law, actually observe customary law, as this constitutes a development in accordance with the spirit, the purport, and objects of the Constitution within the community. So it is therefore important that actual customs at present must be considered. In doing so, expert evidence could assist, but someone with personal knowledge could also testify about current customs and customary law. Ms. Jela, I trust that this was insightful and would give you the viewers an insight with the requirements that is necessary for customary marriage to take place in terms of the recognition of Customary Marriages Act. Thank you.
Thanks for that, Colin. Thank you for availing yourself. Goodbye.